Hello, my name is Brian Havel and I'm Director of the International Aviation Law Institute at DePaul University College of Law in Chicago. I want to welcome you to the sixth installment of the Institute's oral history program, Conversations with Aviation Leaders, which explores the origins, history, record, and future direction of U.S. airline deregulation as told through the voices and memories of its participants. Our format today, as it has been in the past, will be 3 one-hour sessions, and we'll be paying special attention in this program to the emergence and implementation of an ambitious U.S. effort to extend at least some of the features of domestic airline deregulation to the international sphere through a policy known as open skies. But today's guest, I hope, will also travel back with us to the period before the arrival of a formal open skies policy in the early 1990s and help us to understand the first stirrings of international air transport liberalization during the preceding decade. And my guest today, to talk about all of these things, is Jeffrey N. Shane, who is described by one of our previous interviewees, Bob Crandall, as one of the principal movers of U.S. transportation and aviation policy for many years. And by another of our interviewees, former Chief U.S. Aviation Negotiator John Barley, in his conversation with us in October 2010, as, quote, one of the great thinkers at the forefront of aviation policy, unquote. A person who can, resume quote, step back from the trees and see the whole forest, able to articulate tough ideas in understandable terms, and in many ways the originator of the open skies concept and the person who drove it forward, unquote. We'll see, Jeff, if that turns out to be a valid claim as we chat this morning. Jeffrey Shane has a distinguished career in both public service and private legal practice. He served in a number of policymaking capacities at the Department of Transportation, and he was also Chief Aviation Negotiator for a period of time at the Department of State. All of that happened between 1979 and 1993, and he returned to government service in 2002, serving until 2008, and culminating in his appointment as DOT Undersecretary of Transportation for Policy between 2003 and 2008, which gave him a critical role in the emergence of the historic 2007 US-EU Air Transport Agreement. Jeff holds an undergraduate degree from Princeton University and a law degree from Columbia Law School, I should say, where he was articles editor of the Columbia Journal of Law and Social Problems. He is currently a partner with the Hogan Lovells law firm in Washington, D.C., where he practices principally devoted to domestic and international transportation issues, with particular focus on strategic, regulatory, legislative, and transactional advice and representation. He's the recipient of many professional recognitions, including Aviation Week's L. Welsh Pogue Award for Lifetime Achievement in Aviation, which I think is the top award in this field for those who've served the international aviation industry. And I was myself in the visitors gallery at the International Civil Aviation Organization in Montreal in 2007, when Jeff Shane took the gavel as the first American to serve as president of the ICAO Triennial Assembly since 1959. That was quite an achievement. There's a great deal more to say about you, Jeff, including your service as a professor of international transportation law for a period at Georgetown University, but that will simply prolong my words of introduction, and we need to hear from you. And I hope to have given in these introductory remarks a flavor to our audience of your commanding professional involvement in the evolution of U.S. aviation law and policy. And again, welcome to the International Aviation Law Institute, and welcome back to Chicago. I know you haven't been here for some time. In this first hour, we'll be looking at some of the background to deregulation and some of the early liberalization efforts that preceded open skies in the 1990s. Now, as I said in my introduction, you had a number of positions that you held over the years, and let me quickly recite that in 1979 you were DOT Assistant General Counsel for International Law, up to 83. From 83 to 85, DOT Deputy Assistant Secretary for Policy and International Affairs. From 85 to 89, Deputy Assistant Secretary of State for Transportation Affairs. You moved over to the Department of State. And then from 89 to 93, back to the DOT as Assistant Secretary for Policy and International Affairs. About 15 years of holding those appointments, then into private practice, and then you returned to government in 2002, and you serve as DOT Undersecretary of Transportation for Policy. So let me ask you, Jeff, perhaps to take us back through your career in public service, the evolving nature of your responsibilities, and to what extent some of those responsibilities turned from being career appointments in the public service and became political appointments, which I think is a subject of some interest. Again, this is not a deposition, but I'm interested in hearing your CV.
Well, thank you, Brian. First, before I get to the question, I just wanted to express my heartfelt thanks to you, to the Institute, not just for having me here as one of your subjects, but for really understanding the importance of the transformations that took place in international aviation policy, highlighting them as sort of iconic examples of what happens when government is working. I think there are some very important lessons in the transformations that we're going to be looking at today and that you've looked at in previous interviews for some of the problems facing the country today. And it's really interesting to look back, even for those of us who participated in it, to try to understand why these important sea changes in government policy were possible, and why at a time when we desperately need similar sea changes today, they don't seem to be taking place. So this is a very interesting enterprise, and I'm very excited to be part of it.
So you want to see sea changes in the aviation industry?
It's an intermodal metaphor, yes,
Okay.
because intermodalism is, of course, an important theme at the Department of Transportation. And I'm particularly privileged to be interviewed by none less than the director of the International Aviation Law Institute, so thank you so much for the time that you've put into this.
Thank you.
Anyway, going back to the question about this checkered career that you've just outlined, I think it's probably not unfair to look back even further, just briefly, because my first tour of duty with the Department of Transportation actually began in 1968. The department had only been created a year before. I had been working at an independent regulatory agency called the Federal Power Commission for 2 years as a trial lawyer, meaning an administrative litigator. I had been in a lot of natural gas pipeline rate cases, believe it or not. It's sort of fascinating to think about why was I there and why was I doing that? And the answer is simply that while I didn't like law school very much, the subject that I disliked the least, believe it or not, was economic regulation. There was a craft to it that appealed to my anal compulsive nature, and administrative law was sort of a nice hermetically sealed system within which I thought I could work quite effectively. And I actually became a research assistant to a law professor at Columbia who was writing a book about state regulation of utilities.
Who was that?
Ken Jones, William Kenneth Jones.
Right.
He was a fixture on the New York Public Utilities Commission for many years, and a great man, one of the seminal thinkers, I think, about utilities regulation. So I grew up in this culture of utilities regulation, and so that's why when I came to Washington, I wanted to work for a regulatory agency, and the Federal Power Commission at that time, regulating both electricity and natural gas, was a classic regulatory agency. And when I moved from the FPC to the Department of Transportation after DOT was created, it was very much for the same sort of job. DOT understood that an enormous amount of transportation policy was still being made in independent regulatory agencies, the CAB, of course, but also the Interstate Commerce Commission, the Federal Maritime Commission. And it was an executive branch agency. Nothing in the law that created the Department of Transportation enabled it to pronounce on transportation policy issues that were still the purview of these independent agencies. If we were going to have any effect on transportation policy, we had to basically put on a case. We had to litigate before these agencies and try to make our case for a different approach. And that in many ways was my first introduction to an effort to liberalize some regulatory structures that had been in place for a long, long time. This is, I apologize for this aside because it's probably going back a little too far, but I'm still in touch with a great man named Alan Boyd. Alan Boyd was the very first Secretary of Transportation. He was he had been a chairman of the CAB.
Well, back about 1965?
He was chairman, I think, in 64 or 65. He then became an Undersecretary of Commerce for Transportation, which was the highest level transportation policy position in the government prior to the Department of Transportation. And President Lyndon Johnson went to him, he knew him personally, and said, I want you to draft the law that will create this new cabinet agency. Remember, Lyndon Johnson created the Department of Transportation. He also created HUD. He was very much about trying to make government more efficient by pulling a lot of disparate threads under one roof and make them work better. Alan Boyd told me not too long ago that in the first draft of the law that became the Department of Transportation, he included a whole chapter on deregulation. He wanted to deregulate modes of transportation that were being overregulated, he felt, based on his own regulatory experience.
Did he use the term deregulation, or was he using a term like regulatory reform, which sort of preceded deregulation in the formation of public policy?
He used the term deregulation. Now, whether he would have used it in 1965, I don't know.
Yeah.
It has become, after all, a pretty important term.
Yeah.
But he felt that this was, if they were really going to get their arms around some of the issues in transportation policy, a huge step forward in that regard was an important piece of the puzzle. Lyndon Johnson, by his telling, said, young man, let's do one thing at a time. I'd like to create this department. If you throw deregulation in, whatever he called it, we'll never get this done, because he anticipated that there'd be plenty of opposition. So the Department of Transportation, because it was being led by Alan Boyd, he became the first Secretary of Transportation, went to these independent regulatory agencies in the context of actual on-the-record proceedings with a very deregulatory or liberalizing approach. And some of the cases are funny. You know, Brian, that I'm an incorrigible pack rat, and I have all the files, and so I actually have the briefs that I wrote before these agencies at that time. Just to give you one particularly silly example, there was a case called the Substituted Service Investigation at the CAB. It had been the rule that if you tendered a package to an airline because you wanted to travel by air, you wanted it to be air cargo, the airline had no alternative but to make sure that it was transported by air. If the airplane broke down, if they knew it was going to be on the ground for an entire day and they might be able to get it to the destination by truck, too bad, you had paid for air transportation, and by God, you were going to get air transportation because that's what the CAB rule said. The CAB began to question whether or not that was a sensible rule, particularly because you could probably get the package to its destination the next morning on a truck, but it wasn't allowed. And so I represented the Department of Transportation in the Substituted Service Investigation to make the very profound point that if it's possible to get the package to its destination by the time the consignor wants it there, perhaps it should be allowed. And the CAB in its wisdom said, yes, we will allow it. So henceforth, if the airplane broke down, the transportation could still take place.
So that was the sense of liberalization at the time.
That was the quality of liberalization we were talking about at the time. We also did a lot of rate cases. It was a very interesting introduction. So I was at the Department of Transportation in that role for about 4 years. I left government for quite a long time. I became more of an environmental lawyer, I should say, because environmental controversies were very much the biggest issue of the time, particularly in the context of public works, highways being put through towns without much of democratic participation in the planning process, runways being extended and so forth. Progress being made, but not being made in a way that really enhanced the franchise that citizens had. So there was a lot of litigation about that, and I came away thinking that I was really an environmental lawyer. And I did spend the next several years doing environmental law, both overseas in Southeast Asia and back in Washington. I worked for the UN Development Program for a while, based in Bangkok.
When did you leave government service the first time then?
1972.
So between 72 and 79 you were talking about?
I was out. Yes. And then when I was invited to an interview to talk about the first job in 1979, the Assistant General Counsel job, I did it very reluctantly.
Now, Carter was president at the time, is that correct?
Carter was president at the time.
So this was not a political appointment?
It was not. No, this was just a career civil service appointment. I was quite reluctant, actually, to even show up at that interview because I had worked at the Department of Transportation for 4 years, and I thought the idea of going back and treading the same corridors and probably seeing the same memos on the same desks 7 years later didn't seem like a very smart move.
Right.
But I did the interview as a favor to a former boss who asked me to, and when the general counsel at the time, a woman named Linda Cam, described the job, I began to have second thoughts. It sounded quite interesting. This was Assistant General Counsel for International Law. We hadn't done much international law at the department when I had been there before. And she said something about you have to pay attention to these negotiations that we have with other countries. I had no idea what she was talking about. That sounded good. The most important reason I wanted to take the job had nothing to do with that. It had to do with the fact that it would give me an opportunity to supervise somebody. You know, supervisory jobs are like credit cards, Brian. If you've never had one, you're not eligible to get one. And I had found that not having supervised anybody had become a real obstacle to the kinds of positions that I had been applying for. So the fact that I was going to be a supervisor meant that I would finally check that box, and who knew where my career would go from there.
Okay.
So that's why I took that job. It did, in fact, introduce me.
There were no kerosene fumes involved in this. You know, you weren't.
I was not.
Aviation was not flowing through your veins and arteries at this point.
No. Like Mike Levine, whom you interviewed in 2006, I think.
Mm-hmm. That's correct.
I lived just a few miles from what was then called Idlewild Airport. My favorite cheap date was to drive to the observation deck and watch airplanes taking off. But it was really because it was cheaper than taking my date to dinner. It was not because I was so dramatically in love with airplanes. No, I can't qualify myself as a lifelong aviation buff. I sleepwalked into this business.
Okay.
But the bilateral negotiations that were taking place, and I had to participate in those as a member of the delegation once I became the Assistant General Counsel, did seem pretty interesting. My staff, who had been working on these things for quite a long time, of course, had to give me an education into the intricacies of third freedom, fourth freedom, fifth freedom. I mean, I didn't understand any of that. I could see, however, that none of it had anything to do with freedom. But eventually I figured it out, and it became more and more fascinating, particularly because, number one, you could travel everywhere to meet your counterparts in their capitals, and because the issues seemed to be important, particularly to the airline industry. This, remember, was now during the Carter administration. The Carter administration had begun the process of taking domestic deregulation, which was already a fact, it had happened in 1978, into the negotiating process, not with the idea that we could, even through an agreement, completely deregulate the air transportation between the U.S. and a trading partner, but that we could at least liberalize those agreements to the point where governments would stop regulating the price of air transportation or the capacity or even the number of airlines serving a market, the destinations. We were trying to make real progress in that way. We were successful, as the record will show. A lot of so-called liberal bilateral agreements were being forged at that time.
From the very first time you went into the Department of Transportation in 1979, then you were working on these liberal bilaterals. That designation of international law in your title was aimed at these negotiations. That was the context and substance of
that was a part of the job. I mean, I also had a maritime component and even a cross-border surface transportation responsibility. We had trucking with Mexico and Canada, and I had to think about some of the issues there. But it was mostly about aviation.
I want to come back to the bilaterals and how you proceeded with those, but before we do that, you had an interesting vantage point in 1979, coming back after the passage of the Airline Deregulation Act, and domestic deregulation had occurred or was beginning to unfold. What was your perception of how things were at the Department of Transportation and the CAB at that time, looking at deregulation? You didn't have the same investment in its success that some of your predecessors may have had.
That's right.
You were coming in to look at this process. Recollect for us what you found when you arrived and what the situation was with deregulation at that time, from the perspective of the DOT.
Right. Well, the President had essentially embraced deregulation, of course. The Congress enacted it through the efforts of Senator Kennedy. All of that has been, well documented, even in your interviews. And so there was really no questioning the domestic deregulation achievement. That was a part of our culture at this point. And in fact, in the early 80s, there was a pretty serious recession, and traffic was drying up pretty quickly, and the airlines were doing very poorly. And there was some effort by the industry, as I recall, to blame deregulation on what had become a pretty negative performance. And I recall attending a number of hearings, even as a witness or accompanying the General Counsel of the Department of Transportation at hearings which were designed to examine that question. Was deregulation a mistake? Are we now?
Already?
Yes. I mean, this was 1981. No, I'm sorry. It would have been 79 and 80, actually, because I remember the witness, and she would not have been there after 1980. So there was a genuine effort to explore whether or not deregulation made sense, given the economic performance of the airlines just a couple of years into the deregulation process. And the Department of Transportation was steadfastly in favor of defending it and maintaining it. And in fairness, Congress never touched a hair on the head of deregulation. We went through that process, and by the time the 80s had ended, the airlines were making record profits again. So the downturn in the airlines' fortunes clearly had nothing to do with deregulation. In fact, deregulation may have rescued them in many ways at the end. But DOT was very much in favor of that. If you look at the international side, however, the extension of deregulatory principles to these bilateral relationships, there were real tensions within the administration. The CAB was, of course, the most aggressive. The State Department was, I think, in favor of liberalizing as a tropism, as an economic policy instinct. The Department of Transportation was in favor of liberalizing, but in a much more, I guess, putting quotes around it, realistic way, in a practical way. Remember that we had chosen instruments at that time. The majority of international air services were being provided by Pan Am, by TWA, by Northwest Orient to the Pacific.
What do you mean by chosen instruments?
Well, they had been identified as the airlines who would, in effect, be given the international route rights that our negotiators were able to develop through this bilateral negotiating process. Mm-hmm. We had another group of domestic carriers that were just beginning to dip their toe into some of these international markets, but for the most part, they were feeders to the international carriers, and the mm-hmm. international carriers, well known, would be the ones that our trading partners expected to see. As a result of deregulation, given the fact that now our domestic airlines were producing huge hub and spoke systems that would be able to feed international routes in a very efficient way, the Americans and the Deltas and Continentals and Uniteds all became very interested in international routes, and they insisted that there be an opening up of these markets.
Well, what time frame are we talking about?
The time frame that I came to the Department of Transportation in 1979, 80, 81, 82, 83. Mm-hmm. And so the DOT was nervous about opening the floodgates to competition in a way that damaged the incumbent carriers. The feeling seemed to be not to resist liberalization per se, but to do it in an incremental way such that the Pan Ams and the TWAs would not be wiped from the face of the earth by this aggressive new competition coming from this jungle of a deregulated market that we had created.
What was the inciting event that caused international liberalization to become part of the deregulation thinking? You mentioned in your Catete lecture that there was a letter from Carter in 1977
yes.
to the Department of Transportation, which may have been at least one.
Well, that was. I mean, if you're looking for a single event, it was
it
was a decision by the president. And I was eating lotus. I was working for the UN in Bangkok during this time, so I have no insight into precisely who produced that mm-hmm. that very important change in policy. But Carter wrote this memorandum or signed it that went to the agencies involved in international aviation, and it said, let's stop trading restrictions, which is of course what the process had been. Let's begin trading opportunities.
Right.
Let's demonstrate that we're prepared to open our market if in fact our trading partners are prepared to open their markets. And it was a very different take on the negotiating process.
But that was a remarkable change in thinking.
Only a year before, 1976, the Department of Transportation put out an international aviation policy statement, which I still have a copy of. and it said, of course, we believe in competition, and we believe in competition in international markets as well as domestic markets. But believing in competition doesn't mean that there has to be any number of airlines on an international route.
Right.
It was very much a traditionalist policy. It essentially, it validated years of conventional thinking about how we needed to calibrate the amount of capacity that airlines could put on international routes. And that was very much in the interest of making sure that the Pan Ams and the TWAs, the traditional international carriers, were not challenged too much. And that continued to be in some form, notwithstanding the fact that we had this Carter policy, in some respects, a continuing view of the Department of Transportation. Let's not move this ball too quickly down the field. We have to do it in a measured way.
Did this whole change in thinking also have something to do with the Civil Aeronautics Board's order to show cause, which I think had occurred in 1978, the year before you arrived?
Mm-hmm.
A show cause why the United States should not terminate IATA's antitrust immunity. Maybe if you would speak to that, what that was that the Department of Transportation was focusing on, what IATA was doing, and how that shifted thinking in its own way.
The CAB was an independent regulatory agency, and it really was independent. It wasn't just a formal designation. They didn't have to check with anybody before doing anything. That was the nature of the structure. And as far as I know, they didn't check with anybody before deciding to put out this order to show cause.
Who was chairman at the time? Do you remember?
Fred Kahn would have been chairman.
At the time of the order to show cause?
I believe so. I know. I don't think I overlapped with Kahn as chairman. I think Marvin Cohen had become chairman by the time I arrived. But I believe the order to show cause was put out while Kahn was still there.
Okay.
That can be checked.
Yeah.
In any event, the board didn't change at all when Kahn left. Marvin Cohen basically kept the torch burning, and of course Mike Levine was still there, pushing the envelope as hard as he possibly could. My recollection of the order to show cause by the time I arrived in government was that it had been a huge source of internecine trouble within the agencies. It was an order to show cause. Remember that the U.S. government, in its initial legal structure, did not have, even the CAB did not regulate rates for international air services in the traditional way, because they didn't have to, because there was this cartel called IATA, and because IATA would serve up rate agreements that would essentially define what airlines would charge for taking a passenger between one point and another. These were elaborate agreements, and airlines violated them at their peril because they were actually enforceable in some ways by IATA. IATA saw itself as almost a quasi-governmental agency, and the CAB would, to the extent it had power over rates, it had that power only through its ability to approve or disapprove those agreements. Those agreements needed antitrust immunity under aviation law, and that was the control which the CAB exercised over rate making. Once we began doing more liberal bilateral agreements, and one of the big objectives was to get governments to stop insisting on these rate agreements, allow airlines to price the services in keeping with what the market actually would want, the CAB became very skeptical of these IATA agreements. And it simply thought, as a matter of logic, a logical next step in our effort to liberalize pricing regulation would be to put this long-standing system of inter-carrier agreements over price, put that system to sleep entirely. And that made sense. I mean, if you really were serious about trying to get away from this way of regulating rates or allowing rates to be set by the carriers themselves, that's what you would do.
But they were put to sleep over a period of time. The OSC didn't do it immediately. It was a proceeding.
I'm just saying what the intention was in the order to show cause. The reason the order to show one big reason the order to show cause was so problematic was that it was an order to show cause. It basically said, we've already decided to put this system to sleep. Give us a few reasons why we shouldn't, and see if you can persuade us not to. It was a fait accompli.
Right.
And this, of course, went around the world. The order to show cause was addressed at IATA rate making, or rate fixing, I should say, globally. And not surprisingly, it created a firestorm among our trading partners. And from my perspective, even coming in as late as I did in 1979, it clearly had represented a huge setback at that time in our effort to carve out more liberal agreements generally, because it had created such tension between us and even like-minded trading partners. People abroad were offended that the CAB, just because of the power of the U.S., because of the size of its aviation market, that it would arrogate to itself the power to pronounce life or death over a system that the entire world had embraced from time immemorial. So it really, I think, the CAB order to show cause was a highly controversial and perceived as a highly offensive step forward. Now, looking, from the vantage point of hindsight, what happened was that eventually we had a multilateral discussion with particularly our European friends, all of whom were represented through the auspices of ECAC, the European Civil Aviation Conference.
Right.
And what we did in a very clever way, without doing a treaty, without doing a government-to-government agreement of any kind, was established through some sort of a joint memorandum of understanding among civil aviation authorities that the CAAs in Europe and the US would in effect create zones of reasonableness, that carriers would not be prohibited from setting price according to their commercial instincts as long as they were within these zones. And that was designed specifically to persuade the CAB to terminate its show cause proceeding.
When was this?
1982 was when that was done. The show cause proceeding wasn't formally terminated until sometime, I believe, in 1985, and in fact it was terminated by the Department of Transportation because the CAB had already disappeared from the scene by that time. But the CAB, the show cause proceeding was no longer perceived as a threat once we did the so-called US ECAC tariffs agreement, because that was the most important first step toward the real deregulation of pricing in international markets.
Well, I'm still trying to track back through the mentality or the thinking at the DOT around this time. And then there's one other element that I wonder if you could comment on that must have been influencing thinking, and that's the Bermuda II denunciation by the United Kingdom in 1977. And that must have had, in effect, that the Bermuda II being the illiberal agreement.
Yes.
Or rather, I should say the denunciation of Bermuda I and the substitution of Bermuda II for that. Did that influence people, the thought that there should now be an effort toward liberalization?
I recall our thinking about Bermuda II being very much compartmentalized. I don't recall the US-UK relationship, which is sort of sui generis in many ways, as really being part and parcel of the more general policy approach that we were taking toward bilateral negotiations and international aviation generally. You're right, Brian. I mean, the Bermuda I had been a fairly liberal agreement, particularly for 1946 when it was crafted. It was very clear that the UK began to think that the lion's share of benefits under that agreement were flowing to the US, and it had become a political problem for the Callahan government. And they threatened to simply terminate all flying between the US and the UK unless there was a renegotiation. Carter, for whatever reason, took that threat seriously. Alan Boyd, our first Secretary of Transportation, whom I mentioned, was given the role of special ambassador, and he led the U.S. delegation in those talks, but was being pushed very hard by the Carter White House to come to an accommodation with our friends in the UK such that we would not have a cessation of services. The net result was an agreement which, from the UK perspective, balanced the opportunities to a much greater extent, but from the perspective of U.S. airlines, gave away a lot of things that had been in our pocket from 1946 on. Most importantly, as it turned out, giving up one of the two U.S. airlines that was allowed to fly from Boston to London. That became a problem because the Speaker of the House of Representatives was one Tip O'Neill from Boston, and Senator Kennedy, no small figure in the Democratic Party at that time, and no small influence on the Democratic president at the time, Jimmy Carter, was also from Boston. And they basically came to the Carter White House and they said, oh, that agreement you just did that gave up one of the two airlines that was serving Boston, London, do that one over again. which led to another negotiation, which I was present for in 1980, which we call variously Bermuda 2A, Bermuda 2.5. I mean, I was still new to the process, but even I could see that we were basically being taken to the cleaners at that point. You never go into a negotiation with the other side understanding how hungry you are for a particular concession. So they basically said, oh, you want to put that airline back at Boston, that second airline? Happy to do it. Let's talk price. And the price was a very big price. And we can talk about it later. The most important part of the price, as history will show, was an insistence by the UK and an agreement by the US that the two airlines that were allowed to fly from the US to London Heathrow, would be forever named Pan American World Airways and TWA, Trans World Airlines. The carriers were not, they were not just designations, as we say, for the US to figure out how to fill. They were going to be those two airlines. And that was done quite intentionally by the UK because they were even then basket cases, and British Airways or its predecessors were quite happy to compete with Pan Am and TWA, very unhappy about the prospect of competing with any of the new breed of deregulated, these creatures of deregulation that were now
So
hungry.
TWA and Pan Am were separately negotiated after Bermuda 2. That notion of the permanent designation came in the Bermuda 2.5 or 2.5,
Precisely.
whatever it might be.
In order to get that
In order
second
to
carrier back at
to create
at
the
Boston.
second carrier at Boston.
Yeah, we got some other concessions too. I think there was a second carrier at Miami and a few other things, but that was a very important concession.
And what was the reaction back home to that?
Well, I guess the people that were complaining most about the things that had been given up in Bermuda 2 could stop complaining because after all that problem had been solved. I think the real consequences of Bermuda 2.5 really weren't felt until years later, particularly when Pan Am and TWA wanted to monetize their route opportunities at Heathrow. They needed cash, and in a normal environment they would have simply been able to sell those routes to any taker. Under the circumstances, we had to beg the UK for permission for them to do that, because whoever now flew to London would not be Pan Am and would not be TWA. As it turned out, it was United and American.
But I take your point that this was compartmentalized. It didn't necessarily influence the whole process of negotiation that went on in the 1980s. So let's come back now to the discussion we had earlier about the nature of the discussion, the negotiations that you conducted in the 1980s with respect to bilateral treaties. And I'll put one more piece of the puzzle together by asking you about the 1979 International Air Transport Competition Act and how that affected, why it was passed for starters, and how that affected what you were doing during your period at DOT in the 1980s.
A lot of airlines who had been incumbent carriers in international markets under the old system had nothing good to say about this effort by the Carter administration to liberalize these international markets. I mean, they were quite comfortable with the regulated competition that existed. It's not that there wasn't competition, but it was very constrained, as you know. And the idea of just sort of blowing away all these restrictions and opening up the floodgates to whomever wanted to serve was not their favorite idea. And so as the Carter administration wound down and the Reagan administration was coming in, a group of them, about 5 airlines, wrote a white paper and handed it, even before, I think, the inauguration of Ronald Reagan, to the incoming administration, basically denouncing the Carter administration's policy as having produced the worst results for U.S. airlines in history, having decimated the U.S. airline industry, and insisting that we go back to the status quo ante or something pretty close to it. The Reagan administration coming in didn't know quite what to make of this, as you would expect, but the new political appointees who came in saw this as a serious enough political problem that a moratorium was placed on all negotiations that lasted, as I recall, several months. At the same time, Congress was hearing from these same folks about how awful the Carter administration's policy had been and what the consequences for the U.S. carriers had been. And there were a whole series of hearings, 7 or 8 hearings, I think, before the Elliott-Libidis Committee, Elliott-Libidis having presided over I think it was the Government Oversight and Operations and Oversight Committee, something like that. He was basically looking at the negotiating process as a process that needed to be examined closely because of the consequences which were being alleged. And the net result of that was it wasn't going to overturn the approach to liberal negotiations completely. It was rather more nuanced. It said, number one, U.S. negotiators have got to focus on the doing business problems which U.S. airlines have all over the world. That's your first objective, is to make sure that it's a level playing field. And that was because the airlines had said that the Carter administration was liberalizing markets in which there was inherent discrimination, that people were doing all sorts of untoward things. In many cases it was true. The airlines were not being allowed to repatriate their monies, they weren't allowed to set up offices, they weren't allowed to even have counters in airports where the competition had plenty of counters. So there were lots of issues there. This new act focused the government's negotiation process on those problems, solved those problems, and then said, and by the way, as to the exchange of opportunities, make sure that henceforth you get as good as you give.
What was the language, do you recall, that was used?
Yes, that henceforth U.S. negotiators should ensure that in any agreement that's crafted with a trading partner, that the rights accorded our foreign trading partner are matched by rights of comparable magnitude for U.S. carriers. And then there were a few additional words that were...
permanent linkage between rights granted and rights given away.
And permanent, thank you, yes. And I think it's probably worth finding that language and reprinting it somewhere, because you really need to see it to understand how daunting it was. It basically said that an agreement henceforth that simply gets the agreement from the foreign government to liberalize pricing, liberalize capacity, liberalize the amount of entry that was possible in the market, and in return giving a foreign airline 6 new gateways in the United States. That was not a good agreement. That was not perceived by Congress, according to the legislation, as getting rights of comparable value for U.S. carriers. They weren't getting incremental route rights. They were only getting liberalization, which they didn't even want. There were a few additional words in the statute, however, and it said, it referred to the communities who would actually be beneficiaries of this air service. Those few words, right at the tail end of that provision, which I wish we had in front of us so we could read, became vitally important as time went on, as we continue to liberalize. It basically said we're going to measure the equality of benefits, not just in terms of airline opportunities, but in terms of the overall economic performance of the U.S. under these agreements, the flow of economic value to U.S. interests more generally than just to the
traveling
U.S.
public.
The one burning question that has been in my mind for years about this was, who put those words in? Because whoever put those words in made open skies possible. As simple as that.
Which words specifically?
The ones that said, when we measure the equality of benefits, that is now a requirement of our law, we measure those benefits not just in terms of the airline beneficiaries, but in terms of benefits that would flow to U.S. communities and even to travelers. We weren't, I can just imagine the 11th hour scrambling within some committee staff as lobbyists for this or that airport, or this or that travel agency, or somebody rushing up and saying, well, we can't just measure benefits in terms of how the airlines are doing. There's a bigger issue here. And managing to, at the very last second, squeeze these additional words in, which became, as I say, vitally important to everything that happened after that.
So there's another piece of context, the IATCA, the International Air Transport Competition
Yeah,
Act.
and make no doubt, I mean, the IATCA, it looked like it was meant to ensure that we protected our airlines against all forms of harm overseas. It was really meant to slow things down, to really put a damper on this quest to liberalize international markets.
Where are you at this point? Have you moved into a
I was still an assistant general counsel.
Political appointment at this point? Or
No. I was a career bureaucrat. I was a civil servant and still doing my job as an assistant general counsel at DOT.
Okay. And tell me about these liberal bilaterals that caused such complaint among the industry participants.
Well, the liberal bilaterals were, in their own way, pretty revolutionary, because we had these sort of Bermuda One format agreements forever where everybody kind of knew what the provisions said. There was never any questioning of that. And the notion that we would actually call some of those traditional provisions into question was quite revolutionary at the time. Now, this started, again, before I got there. It began in 77. By the time I arrived, we already had liberal agreements with people like Belgium and Israel and Jordan and Singapore, I think, had signed one. And
when you say liberal agreements, do you mean open skies?
No. There were no open skies, Brian. This was simply the deregulation of capacity and pricing and entry. That was the main thing, to the extent that we could get an agreement to allow a multiplicity of ground handlers at a foreign airport to compete with each other and not insist that our carriers use a monopoly ground handler, so much the better. But for the most part, it was just the liberalization of these regulatory constructs. We didn't need, U.S. carriers really didn't need new route rights. We pretty much could fly to the destinations that were commercially viable under the Bermuda I agreements. And that became the problem, because we always paid for, they say the U.S. government always paid for, in quotes, this liberalization that we were trying to extract from our trading partners with new route opportunities for the national carriers of the countries we're negotiating with. So with the Dutch, they would give us everything they had to give and liberalize pricing, capacity, and entry and everything else, and give us fifth freedom rights beyond Holland to anywhere in the world. And we would give them 6 new gateways in the U.S. U.S. carriers got no new gateways. U.S. carriers weren't particularly enthusiastic about having more competition, so that wasn't a win for them. And they didn't get any new traffic rights. And so they said, why are we doing this? Why are U.S. government negotiators going out and just making sure that KLM can take a bigger bite out of our market than they can before the agreement is done? So that was really kind of the genesis of that white paper I told you that went to the Reagan administration, and that was the genesis of the Libitus hearings, which produced IATCA. There was a huge amount of questioning about whether this was a very sensible policy. Again, looked at from the very narrow perspective of the U.S. airlines, who had been quite happy with the arrangements that had been in place before.
Were you concerned at all that some of the potential negotiating partners might stampede toward a Bermuda II themselves? Was that a fear inside the department at the time?
No, because the markets just didn't really, I think, the markets we were talking about after the UK were not amenable to that sort of a city pair approach. They just weren't robust enough to justify that sort of a route by route schedule that we had. I mean, pages and pages of routes that were at the end of Bermuda II. That's why I say the UK was sui generis.
So what happens next in the process, going through the 1980s? You've got the hearings, you've got protests from the carriers. Is it a quiescent period, or do you continue to negotiate your more liberal bilaterals?
I remember it being, well, we did more liberal bilaterals after a time. The Reagan administration had that moratorium for a few months, but then really came back to the table. The Reagan administration, of course, was a market-based administration. It believed in market economics, as you know. And so the government negotiating process sort of returned to the status quo ante and continued to try to push the envelope. Not so hard as would have been done under Carter, as I recall. And we had this mandate under IATCA to stamp out discrimination, doing business issues and other things wherever we found them. So that, as much as anything, became a very important part of the negotiating mandate. And I remember it being quite a quiet time in terms of really pushing the ball for liberalization. It became quite different. I moved from the legal office over to the policy office, and I became a deputy assistant secretary for policy. Interestingly, I was there when the CAB was finally put to sleep under the Deregulation Act and the CAB Sunset Act. It was at the end of 1984. Under our regulations, we decided that when there was a limited entry market created by a new bilateral agreement, when one new airline would be allowed to serve some city pair market between a city in the U.S. and a foreign capital, that decision would have to be made by the senior career official in the Office of Policy at the Department of Transportation. And just by happenstance, that was yours truly. So I ended up being, as a career civil servant, the first person at the Department of Transportation that actually made the kinds of route decisions that heretofore had been made by the 5-member Civil Aeronautics Board. And it was a very interesting little episode, because the question before the industry was, could this political department of government, after all, not an independent regulatory agency with none of the fences that are supposed to protect the process, could this political department make a decision about the allocation of a valuable international route opportunity in a way that was perceived as, was actually and perceived as being objective, on the record, and on the merits? And I hope, I like to think that we actually did satisfy the industry that we could do that. But I presided over the very first route proceedings that DOT managed.
After the
sunset of the CAB.
Of the CAB. One has a perception that, I mean, we talked about, I threw in the term open skies and meant in a sense to suggest what's coming in our next hour. We often have the perception that open skies, 1992 is year zero in all of this liberalization internationally, and I think we're getting a different perspective from you in this first hour. But is it fair to say that, that after the initial push toward liberal bilaterals that you talked about, the instigation of the Carter administration, that things became, shall we say, a question of smaller goals with respect to the implementation of IATCA, that there were no dramatic agreements that occurred between the early, the time that Carter left office and the arrival of year zero in 1992?
I would characterize it a little differently. I think small goals might be fair as one part of the phenomenon. But the other thing that I think it's important to recall is that our trading partners were getting increasingly cross with the U.S. They, first of all, we had the IATA show cause proceeding, which continued, on the books until 1985, which was seen as fundamentally offensive and a gross example of U.S. unilateralism. And there was a huge diplomatic effort to try to tamp that concern down, but it was never terribly successful. Even the U.S. effort to buy liberalization by offering route rights to certain U.S. cities was resented, I think, in a way, because, of course, our foreign airline friends wanted more access to this candy store of a market, as I've always called it. It was the most important market on the planet, and they needed it. And we were using that thirst for more access to the U.S. as a way to crowbar our trading partners away from traditional forms of regulation. Eventually, of course, we could do it because they desperately needed the route rights, but they didn't like it. They thought it was offensive, and we were just throwing our weight around. And eventually, they began to see that, and this is one of the great ironies, notwithstanding all of the complaints that we had from U.S. carriers that led to the moratorium, led to IATCA, led to all those difficult hearings, notwithstanding all of their complaining, they were doing marvelously with the new bilateral agreements. I mean, they had taken the opportunities that had been served up to them, even over their own dead bodies, and they were actually exploiting them. And the net result was, because they had these wonderful hub and spoke systems now under deregulation, they were essentially cleaning the clocks of foreign carrier competitors. And the foreign carrier competitors didn't like it and understood it. And so, in addition to kind of winnowing down the goals of negotiating on the U.S. side, we actually had some partners overseas that were getting increasingly difficult, who were really tired of this effort by the U.S. to just muscle its way in, force governments to deregulate international access to their capitals and so forth. And so you really had a lot of forces sort of working against any real further progress in terms of liberalization.
But some major progress did occur in the early 1990s or late 1980s, the cities program.
The cities program was in 1990, I believe. And that was the first Bush administration. So we had now...
And where is Jeff Shane at this point?
Now, Jeff Shane had been the chief negotiator at the State Department from 1985 to 1989, again in a civil service capacity. in other words, presiding over a pretty desultory period in our negotiating history, chasing those doing business problems to the extent possible, every now and then achieving a meaningful agreement, but for the most part, making sure that the world was safe for the Sabre system, making sure that the world was not discriminating too much against U.S. carriers' ability to do this and that, but not really making enormous progress. I was somewhat miraculously given a political appointment in the Bush administration, and I became Assistant Secretary for Policy at the Department of Transportation. So I segued back, having spent 4 years at the Department of State. Much to my astonishment, I was sent back to the Department of Transportation, but in a political position. That was a presidential appointment. I had been thinking a lot about everything that was wrong with the negotiating process for a long time, particularly during the 4 years when I was supposed to be in charge of it. And it just seemed to me increasingly obvious that this effort to obtain benefits for U.S. carriers only when they needed some benefit from the other side was a losing proposition for us. It was getting us nowhere. The fact is, U.S. carriers had just about all the route rights that they wanted, just by virtue of the way the rest of the world is balkanized. The ingredients for making progress simply weren't there. I had made a lot of speeches to chambers of commerce during my time at the State Department, which I have, by the way, because I never throw anything away. I'm happy about that. My wife is very distraught about that. But I still have them, and it's very interesting to see where our heads were. I found, as I went out and spoke to chambers of commerce in various important cities, that they were completely oblivious to this whole bilateral negotiating process, had no idea what was going on, and had no idea the extent to which the airlines had basically dominated the policy making that was going on in Washington. And so I started sort of making these speeches saying, you're not paying attention, and the net result is you're not getting the international connections that you really deserve, that you should have, that would advance your economic growth dramatically. One route, to a foreign capital could increase economic activity in your community by $100 million a year. Why are you not paying attention to that? And
you are now a political official going around to chambers of commerce.
I was not. I was a reckless bureaucrat, civil servant. And I don't know exactly how this happened.
It's an interesting idea that it might have happened, that it did happen.
Well, I had this bad habit of, first of all, I had figured out some time earlier that when you have these positions, whether it's a career position or a political position, but if it has the word secretary in it, I had been a deputy assistant secretary at DOT, and I'd been a deputy assistant secretary at state. When you have the word secretary in it, people actually pay attention to what you say. And so when you said something, it became U.S. policy, if you could get coverage for it. And this is actually a serious point. I mean, for anybody thinking about government service,
right.
I mean, pay attention to this. So I decided that if there was any point to having these jobs, it was to actually make something happen. And one way available to me, as somebody with the word secretary in his title, to make something happen, was to make a speech.
On this intriguing note, we will pause, take a break, and resume our second hour.
Thank you.